ungodly. I can only apologize to the audience that we are broadcasting at this hour because I don't understand time zones. I had intended to set this for 8 p.m. my time and ended up setting it for midnight my time because I'm enumerate. But anyway, we am joined tonight once again by Mr. George Bagby. How are you, George?
I'm doing wonderful. I've been
Excellent.
doing lots of study lately and much enjoying it.
And what do we have on the docket for tonight?
We're going to go deep into John Marshall and his cases, his major landmark Supreme Court cases, which correspond with our previous discussions about the bank debate. Marshall reads Hamilton's opinions, the liberal construction of the Constitution, and also the innovative power of judicial review into our constitutional law through his landmark decisions. And he has a lot to say that determines the course of business law in relation to the federal government. So he is a great giant of the saga of the Bank of the United States. And we're going to cover his opinions before we go back to the history of the bank itself, which we will do in a later episode.
Excellent. And I suppose there is no better place to begin an examination of Marshall's judicial corpus than Marbury versus Madison.
Yes, indeed. We have a history of controversy about this question of judicial review. Just what are the powers invested in the Supreme Court? What is this court supposed to do? We have the testimony of Chief Justice of the Court, Charles Evans Hughes, who is writing in modern times. He's writing around the turn of the century or soon after. He said, "We are under a constitution, but the Constitution is what the judges say it is."
Let's pause here to reflect upon what a radical novelty a Supreme Court was in Anglo-Saxon jurisprudence and what judicial review was in Anglo-Saxon jurisprudence, because when we created the Supreme Court in Article 3 of the Constitution, this was in some ways a very radical break from the way it had been done for the preceding 1,000 years through the history of the English peoples. Judges originally were just officers of the king, and there was no concept of a separate judicial branch. Judges were serving at the pleasure of the king. They were traveling throughout the country, coming to town, deciding cases, and then leaving and going to the next town. It was a very ad hoc affair, which over 1,000 years acquired various appurtenances of formality to it until you had formal courts. But even in the English system, up until the 1990s, the highest judicial body was not a Supreme Court. It was the House of Lords. It was actually legislators who were sitting in judgment following the English Civil War. Again, the legislature at that point had appended unto itself the judicial function. And so breaking it out into an independent branch of government, this was really the first time this had been tried. And so once the Constitution had said there will be a Supreme Court, there was very much a blank space on the map for what that would actually look like. And it was Marshall who stepped into the breach, and some would say usurped, others would say created the role of the Supreme Court as it currently functions in our constitutional system.
That's very interesting. And we can look at the modern history of the United Kingdom to see that they have abolished their old system with the head legislative body above the judges in the House of Lords. Tony Blair instituted reforms to abolish that function in the House of Lords and to actually establish a British Supreme Court. So that was a frank copying, imitation of the American constitutional system by
Correct.
way of Marshall. And
Mhm.
that's a very interesting and recent radical development in British constitutional law. But I think that a good place for us to start here is Article 3 of the Constitution, which actually gives us the boundaries for this branch of the federal government, the Supreme Court. I've got it here in front of me. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation. And some more details. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizen thereof and foreign states, citizens, or subjects. So it outlines a few more details beyond that, but that is the gist of the description of the Supreme Court. It does not specify how many justices, does not specify specifically the famous power of judicial review, though it gives purview to what kind of cases they can hear. Judicial review is novel because this is something that Justice John Marshall actually specifies to some degree, or at some length, I should say, in Marbury versus Madison, which is
Indeed.
our first case today.
Yes, that is its origin, essentially. This was the first opinion pronouncing upon the constitutionality of a law, and it is, by implication, the first assertion of this power of judicial review.
Now, there are a couple of precedents that we should mention in our approach. We recall our discussion about the anti-federalist concerns about the Constitution. They anticipated that the Supreme Court would assert a judicial review power over the states in particular, that eventually this proposed Supreme Court would strike down laws promulgated by the state legislatures and even potentially state constitutions. In both of those instances, those anxieties were completely vindicated.
Indeed.
The Supreme Court now habitually does both things that the anti-federalists feared they might eventually do. And this was an interesting matter among the Federalists themselves. These are the advocates of the Philadelphia Constitution in private, in their own private correspondence. They were talking about this as a potential expansion for their vision of the federal power in the Union. So we have the testimony of a historian of the Supreme Court, J. Allen Smith, who's writing the early part of the 20th century. He said, "No other instance in the whole history of constitutional development, or there is no other instance, where public opinion has been so misled as to the fundamental nature of a political arrangement. The real purpose was to centralize political authority largely in the Supreme Court through the power of final interpretation of law." So this was a matter in which the Federalists dare not be very frank about their ambitions. They allowed this to work itself out through the Marshall Court, and they were successful. When the Supreme Court asserts that it is the final arbiter of what is a legitimate law, both from Congress or from the states, they make themselves an unaccountable branch of government. There is no check on this.
But Mr. Bagby,
really the only
surely Congress could check them by impeaching justices.
Indeed, and Article 3 suggests that very measure. But we see with Jefferson's administration, Jefferson is elected to the presidency in 1800. Jefferson attempts to impeach both Supreme Court Justice Samuel Chase and also federal judges during his administration. Articles of impeachment are passed by the House. The Senate does sit in judgment of the accused, and these judges are acquitted. And to this day, that is the only example of an attempted impeachment of a federal judge or a Supreme Court justice. They ended in failure, and it has not been attempted since.
Well, I'm just amazed that America has been so blessed with such well-behaved judges that it has never been needed since.
It's a remarkable fact about our political history that this was only tried on that one occasion, that one administration.
The only other example I could point to would be FDR's threat to pack the court, would be another theoretical way one could rein in an out-of-control judiciary.
Now, it seems to me, and maybe you can enlighten me on this point, because I'm quite curious, the 9 justices of the Supreme Court, the odd number which will ensure clear majority decisions, is only a tradition.
Would that were the case. There have been many cases where you have dueling pluralities, where neither side can, or neither of 3 or sometimes 4 sides can come to a majority decision. And so a flurry of plurality decisions are issued, but that's neither here nor there.
I haven't considered that. I don't think of a case coming to mind for that. I'm sure I've overlooked that. But is it true in your understanding that the number 9 for Supreme Court justices, this is only a tradition, a convention? This is not based in law.
It's not even an original convention. If memory serves, I think it was originally 7 and was later expanded to 9, but I may be imagining that. I would have to check.
I think in John Marshall's day, it was actually 6.
Yeah.
It was gradually expanded from that point. But that's a curiosity. It doesn't really concern our matter today, but I think that is the case. So that the question of packing the court, expanding the number of justices on the court, has been a recurring theme, famously with Franklin Roosevelt first, but it's reemerged in recent times. So the question of judicial review is first raised by a congressional act, which we'll talk about a little bit more, the Judiciary Act of 1789. So this comes from Washington's administration, or Washington's first Congress. It establishes federal courts, whole system of them, and the original composition of the Supreme Court with 6 justices. It says that the Supreme Court has power to affirm or reverse on appeal state laws after a high court ruling, or that a federal law was in fact unconstitutional. So both of those matters imply the power of judicial review that John Marshall later enumerates. But This is a controversial act from Congress. Not surprisingly, Washington's original Congresses are majority Federalist because they are the supporters of the Constitution. So they basically get what they want with this Judiciary Act. And this is, in retrospect, a kind of power grab. It is a very controversial act with the opposition, with Jefferson's party, and they want to reform the Judiciary Act, and they have an awful lot to say about the faults they find in it. They want to curtail it. The original Judiciary Act is expanded after the Federalists lose the election of 1800. So John Adams loses his bid for re-election, and the Federalists in Congress pass very quickly the 1801 Judiciary Act, which greatly expands the number of federal judges. So this is the Federalists trying to ensure that they will maintain control of the judiciary even after they have been voted out of the coming administration. So we're seeing a majority Republican Congress, Republican in the sense of the old party. This has no connection to the Republican Party of our own day.
The Democratic
Republicans.
Yes.
Exactly. They dominate Congress and they have the executive. So they're coming in, and this is one of the reasons why they are motivated to impeach some of the Federalist judges. The accusation against the Federalist judges that do face impeachment is that they're grandstanding by way of the Sedition Act. So the Sedition Act has criminalized malicious speech against the Federalists of Adams's administration. So the Federalist judges, notably Supreme Court Justice Samuel Chase and a bunch of lesser judges who are not on the Supreme Court but are still federal judges, they grandstand in trials on these sedition cases, which are all being prosecuted against the Democratic Republicans of the day, mostly newspaper editors. And the judges take it on themselves to get up on the bench and make political speeches about the dangers of the political opposition and how they should be curtailed, fined, imprisoned, and so on, that they are dangers to the Republic. So this is what they are being indicted for by the Republican Congress once Jefferson takes the oath of office. And they are acquitted finally by the Senate. So is not a successful effort, even though it looks to me like if there was ever a time in which judges should have been impeached, it would have been this time. So the genesis of Marbury versus Madison, which is our very first case to discuss this evening, this has to do with the 1801 Judiciary Act, this supplemental expansion of the judiciary by this lame duck Congress, by the outgoing president, John Adams. John Adams famously appoints 42 judges of various descriptions. These are not Supreme Court justices. These are lesser judges and federal justices of the peace. He commissions 42 Federalist appointees to judge positions at midnight of his last day in office. So these are very last-minute appointments. And controversially, when Jefferson takes the oath of office, he instructs his Secretary of State, James Madison, the father of the Constitution, formerly a Federalist himself, though he has several changes of heart in the course of his career. James Madison does not mail the commissions. And this is the subject of a suit. So William Marbury, who was appointed to a 2-year appointment as Justice of the Peace in Washington, D.C. So this is a very minor position with a very short term. He litigates against James Madison. So this is Marbury versus Madison. It goes to Marshall's court. Now, Marshall was a slightly earlier appointee by John Adams. John Adams actually puts Marshall into the Supreme Court. He gets rubber stamped by the Federalists Senate, and he becomes the great Chief Justice, the single most influential, important judge in American history.
Mm-hmm.
He receives the request for a mandamus from William Marbury, who had been given this appointment by President Adams. So a mandamus is the power of a court to order something to happen.
And just to quiz you,
Is that
on your legal knowledge, when you read Article 3 to us, you read that the Supreme Court had jurisdiction in cases of law and cases of equity. You remember that?
Yes.
So is a mandamus a case of law or a case of equity?
I believe it's a case of equity.
Correct. Very good.
So this is how John Marshall starts his opinion. If I'm remembering this correctly, I don't have it right in front of me here, but John Marshall begins. Well, maybe I do have it in front of me. Let me check. He begins his opinion in Marbury versus Madison, asking, has the applicant a right to the commission he demands?
Mm-hmm.
If he has the right and that right has been violated, do the laws of his country afford him a remedy? And if they do afford him a remedy, is it a mandamus issuing from this court? So this is a question of equity. Has wrong been done to this man?
Mm-hmm.
And Marshall determines yes, that wrong has been done to him. But this is a very complex case. And
it is.
I think that
it all hinges on the last two words you said, this court. That is what the case turns on.
Indeed. So Marshall had several options here. His intentions are clear. He is a Federalist. He does want to buttress Federalist concerns through his opinion. There's nothing intrinsically wrong with that. I think this seems to be natural. Every statesman has opinions and priorities, and that's going to work itself out in policy. But Marshall could have gone with the mandamus and ordered the president to deliver the commission.
And on the face of it, you would think that would be what he would do, because he's aggregating more power to the Supreme Court, this right to issue mandates to force people to do things. Isn't that the way this would go if Marshall were thirsting to expand the power of the judiciary?
Marshall was likely aware that in the conflict between a appointed judge and an elected president, that the Republican institutions and sentiments of the country would go against him. So he very cleverly decided not to force the issue of his will versus the president's will. He did not demand the mandamus, the special order of the president to deliver the commission.
Mm-hmm.
Instead, he
the
did something
reasoning
horrible.
by which he arrived at that was a much more breathtaking buttress of the court's authority.
Yes, certainly. And even a more striking blow against a Republican form of legislative law.
Mm.
And extremely clever on Marshall's part. Marshall's cases are extremely cunning devices. Every one of them that I've studied in depth. He really is quite brilliant, though I think also insidious. So he says that Marbury is entitled to his commission, but he says that he is technically not allowed to order the delivery of the commission because the 1789 Judiciary Act permitting the Supreme Court to order a mandamus is unconstitutional. So he rules that the legislative act that establishes and describes various powers of the Supreme Court is actually an unconstitutional law. He strikes down a law of Congress in Marbury versus Madison, declaring that Congress does not understand the Constitution.
That it has aggregated to itself powers the Constitution does not give it, which will be ironic in our reading of McCulloch v. Maryland later. But yes, he's foregone the lesser power grab in order to reach what has turned out to be the ultimate power grab, the power to say what the Constitution is.
Yes. Which, and I would really like your reading on this. This seems to be the result of the optimistic Enlightenment mind meeting the realities of political power.
Very
it
much
seems
so.
to me.
Yeah, I mean, the remark you made a few minutes ago about Marshall not wanting to put to create a battle of wills between himself and the president, between this appointed judge and this elected president, is one aspect of that power dynamic. But more realistically, this is a prefiguration of the managerial revolution, where you wield power through procedural gambits. Affecting procedural outcomes allows you to wield far greater power than picking up a sword or picking up a pen and doing battle in the court of public opinion. And Marshall is a master of this.
And as you noted, he's not entirely consistent on the point. We can look through his landmark decisions, and we might think that we know what he is going to decide based on a previous ruling and his stated opinion about a particular matter. And then he does something else that surprises us. So he's extremely cunning, and I think that he has a cohesive vision, but his cases frequently surprise us when we consider what we might pick up as the import of a previous landmark decision.
This is a trait that would be repeated in Oliver Wendell Holmes a century and a quarter later. The two figures, their minds, in my mind, work very similarly.
This is quite remarkable because John Marshall did not have a legal education. He went to William and Mary, but did not specialize in law. And yet he became our most famous legal source concerning the Constitution.
No,
so
neither did he.
I think the man was a genius.
Oh, certainly. But you're right. He doesn't write like other judges do. He proceeds. His opinions are written as a series of assertions rather than syllogisms. It cannot be doubted this. It is objected that, and then he asserts something, and then doesn't offer any precedent or any syllogistic support for it. He writes a lot like Nietzsche, actually. He just makes these fine-sounding assertions and builds them one on top of another to sort of hypnotically lead you to a conclusion.
I find myself often disturbed by the use of the passive voice in these Supreme Court decisions, as I am disturbed whenever I find it in a political speech. Is this a commonplace? You read a lot more of these than I do.
More than read it, that's how I was taught to write. You switch between the active and passive voice depending on the point you are making. If you are a defense attorney, a stabbing happened. If you're a prosecutor, he stabbed the man. You lawyers are trained very strategically to switch between the active and passive voice as it serves their argument.
I did not know that was a mode of instruction in law.
Oh yeah.
I see the utility. The utility is obvious. But I am a campaigner against the passive voice. I loathe the passive voice, and I'm always alarmed when I read it.
And don't be a
because I
defense
believe
attorney.
There's something else going on. Whenever I read the passive voice from a very informed party like John Marshall, I know that he is trying to do something to me.
Yeah, that at least is a hoary old legal trick. Yes,
it's a very effective legal trick.
Mm-hmm.
He posits ideas in his reader by doing that.
Yes.
Well, so Marshall in Marbury versus Madison, he establishes a precedent of judicial review by asserting it. He does make reference to the Judiciary Act, which does make certain implications about judicial review, but he does not rely on precedent. He asserts that the Supreme Court has the power to review the constitutionality of law and to mark it as void when they find that, in their opinion, it's unconstitutional. So this is the fundamental power of the Supreme Court following, and the source of a tremendous amount of controversy, because as you opened our discussion, this is something that is unprecedented in the English legal tradition. We did not practice this until John Marshall asserted it in Marbury versus Madison.
Yes. And
so
go ahead.
According to historian of the court, Fred Rodell, the Supreme Court may not be ordered to do something, but may order.
Mm-hmm. Yes, that's right.
And curiously, John Marshall does this specifically while striking down the provision of the 1789 Judiciary Act that permits the Supreme Court to make an order. He strikes that down while asserting the Supreme Court can order. Just not in this particular technical way.
Right. Well, that technical way is very important, because he grounds the distinction wherein he finds the law unconstitutional upon this distinction between original and appellate jurisdiction. And these two procedural postures in the original court and in the appellate court are very, very different. So this is actually a substantive point of law. A court with original jurisdiction is a trial court. There's a judge, typically there's a jury, evidence is heard, and a decision is reached. When that decision is appealed, the appellate court doesn't hold another trial. The appellate court reads the record and is strictly limited to what's in the four corners of that record. And in some ways, it's a much more constrained analysis, because the court has to give deference to the trial court on a great many issues. Various questions are subjected to different standards before they can be overturned. So an appellate court is much more constrained in what it can do with the case after the trial court has passed it on to it. So this distinction between original and appellate jurisdiction is a substantive one, but Marshall, of course, uses it to do everything we've said he's done.
Making the Supreme Court a super legislative body.
Correct.
In fact. And this is very different than the appellate court function. A court of appeal, either on the state level or federal level, they basically have to look over the case under review, and they have to point out that something went wrong in the originating court's decision.
Correct.
They have to identify something there and then overturn that decision based on a legal technicality. Is that a fair description?
That is exactly how it works.
Okay. So the Supreme Court, through Marbury versus Madison, becomes something far bigger than an appellate court.
Mm-hmm. And by extension, all the courts under it also aggregate this power. For, as we see in our own day, district judges are in the easy habit of overturning laws and actions of the executive as being unconstitutional. So the power doesn't rest solely with the Supreme Court. It is the judiciary as a body who has aggregated to itself this right to say what the law is.
Indeed. Well, I've got some notes here on other landmark decisions. We're working our way towards McCulloch versus Maryland, which is the great Bank of the United States case, the 1819 landmark case. But before we get there, I wanted to go over Dartmouth versus Woodward, which is a very interesting case.
Mm-hmm.
And I'm very interested in your opinions about this. So Dartmouth College in New Hampshire was chartered by King George III and had become a hotbed of federalism in a increasingly Republican state by 1819. So the New Hampshire state government wanted to modify the charter of Dartmouth College and basically make it a public university. The state wanted latitude to appoint their own board members, and were concerned about the political convictions of the old board, which were all old Federalists at this point. So they were an old regime, and they wanted to modify it. So they appeal the modification of their charter. They hire Daniel Webster, who is a very important American statesman. He is born in New Hampshire, attends Dartmouth College for his undergraduate, later on becomes Senator of Massachusetts and one of the great giants of his day. Now, this is actually after the demise of the Federalist Party. This takes place after 1814 and the virtual implosion of the Federalist Party, which is another matter. But Webster's defense of his alma mater is very famous. He goes in front of Marshall's court and he says, "It is a small college, but there are those who love it." And it's this very emotional rhetorical appeal that he becomes very famous for later. It's one of his most famous lines. But Marshall's response to this is he takes it upon himself to assert that charters are legal contracts and that states may not abrogate legal contracts, that they are unregulatable and virtually unchangeable. Now, this is very interesting because states do set up legal corporations. So do not states then have sovereignty over these special legal devices? Can you enlighten me about the history of this?
So it's an interesting question because a corporation fundamentally is the creature of a sovereign state. It is, as we've discussed in previous episodes, an artificial person created ex nihilo. And the state's relationship to its corporations has tended over time to distance. Nowadays, anyone can start a corporation. The states, charge a registration fee and make you file an annual report, but they tend to be fairly hands-off. This was not the case in the past. States could be heavily involved in corporations, particularly public corporations in which the state itself maintained an ownership interest. So we have to distinguish between two things here: the state as a charterer of a corporation and the state as an owner of a corporation. And what's going on here is the state is not asserting its rights as a charterer of a corporation, because of course the state didn't charter Dartmouth College, the king did, but that's a historical accident. The state is asserting ownership of the corporation, not its a pertinent sovereign power of chartering a corporation here. So there's two different things going on, and it is the latter which is the issue, to the point that I'm actually surprised there wasn't any argument about the takings clause in this case. But they decided under the contract clause, which is a whole separate lecture of how the contract clause has been gutted during the New Deal in the 1920s, 1930s. The judiciary's understanding of the contract clause underwent a radical shift, such that the issues being debated in this case would not even be recognizable to a court today, but they were then.
Very interesting. My analysis of this case comes mostly from agrarian writers during the New Deal. And Herbert Agar, who is a great historian, he won the Pulitzer back in the day. He edited a volume called Who Owns America, and collected a bunch of very interesting essays. If you want to have your mind blown with agrarian policy proposals for modern times, this is a delightful read, and I highly recommend it. It even has an essay in it by Hilaire Belloc, who contributed to this volume. But you find a lot of skeptics of state chartered corporations, or federally chartered corporations for that matter. They want to regulate these things, and they are offering revision of the Dartmouth case. So they warn against the dangers of these immortal legal persons accumulating capital and wealth that survives all general property for actual personal property, saying that these two kinds of property are in fundamental conflict with one another. And so they're attacking the charter is a sacred contract, which may not be abrogated.
Indeed, it is.
But anyway, one of the results of the one of the results of the Dartmouth College case is a newfound confidence in corporate security, ruled that corporations may not be interfered with or abolished by state governments, that it amounts to a contract, and as the Constitution says, there shall be no laws impeding contracts. This gives a new confidence to the merchant class to invest in corporate securities. So this is a notable result of the Dartmouth College case. It is buttressing the security of corporations.
Yeah, it's interesting. A charter could be a contract, but isn't necessarily a contract as contracts are defined. A contract is defined as a set of promises that the law will enforce, arising out of an offer, an acceptance, and the exchange of consideration. A contract must be supported on both sides by someone giving something. Just promising someone something, that's not a contract. That's just a promise, and it's not enforceable. But when you promise someone something in exchange for something, then you have formed a contract. And I would be interested to read the Dartmouth Charter to see what the king expected in return, if anything, as to whether the charter was technically a contract or not.
Well, one of the things the contract said was that they were going to educate Native Americans in Christian theology. And they were not doing that in 1819. So in a panic, the trustees or the board, they direct the college to go out and find unlettered Indians in the wilderness that they could bring into the college as soon as possible. So they were trying to abide by the letter of the charter while they're litigating their case. And this amounts to nothing. They bring some Indians down the Connecticut River, and as soon as they're in sight of the busy city of Hanover, New Hampshire, which has never been a sizable town, the Indians jump overboard, swim to the Vermont shore, and disappear into the wilderness. And so they are never admitted. It's a funny detail of this saga.
A shadow over Hanover.
Well, lastly, we get.
No, go ahead.
We've arrived at our principal secondary landmark decision, McCulloch versus Maryland, which is totally dependent on the former Marbury versus Madison. This is the case where the Supreme Court strikes down a state law, just as the Anti-federalists had foretold was a risk. Here it is finally realized. And this takes place in the same session, 1819. Once again, Daniel Webster is appearing before the court to argue the case. So once again, Webster is building his mammoth reputation as a Hamiltonian thinker, essentially, arguing this case before the Marshal's Court. The matter of McCulloch versus Maryland is that the state of Maryland, out of a Republican conviction that we've already covered in Jefferson's opinion about the Bank of the United States proposal, they have taxed the Bank of the United States in Maryland. The tax is designed to...
They have taxed the second Bank of the United States, and that will figure in Marshall's reasoning.
Yes, indeed. So the Bank of the United States does have, it does expire in its first charter in 1811. So it is liquidated and then rechartered a few years later after the financial troubles of the War of 1812. Something that I'll go into more detail about at a later time. Nevertheless, so this is the second Bank of the United States, and Maryland does not want this bank competing with its own state chartered banks. And also, the Maryland legislators are of a Jeffersonian persuasion about the powers of the federal government. And so they say there is, what did they say? I wrote it down. The Maryland court, which hears the first appeal before it goes to the Supreme Court, the Maryland Supreme Court says the Constitution is silent on the subject of banks and silent on the subject of corporations, obviously. So the ruling is from Marshall. He says the power to tax is the power to destroy, which is a very memorable line from this case and has its own life. But Marshall, in order to make his ruling, he first declares the Bank of the United States is constitutional. He does this in two ways. Well, let's say three ways. First, he says the first Bank of the United States was constitutional. It had its own lifespan, and that's precedent. Secondly, he says the necessary and proper clause of the Constitution gives the federal government implied powers that are not specifically enumerated. Thirdly, he says that the people of the United States at large have commissioned the federal government to do the things in the Constitution. It is not the states who have the creative power over the federal government. The states are not sovereign in relation to the federal government. So this refers to the preamble, which is another Hamiltonian point, the preamble which says, we, the people of the United States. And we may recall back when we were talking about the Anti-Federalists, Patrick Henry said, this is a very serious phrase, because in future times, people are going to say, well, the people established the federal government, that the states did not establish it. Patrick Henry said they should have listed the states.
And of all the wide-ranging implications that this case will have for the future history of the United States, this point is the most important. This is enshrinement into law, what Hamilton argued, what Henry warned of, this principle that the powers of the federal government proceed from the people, not from the states, contra the Jeffersonian and later Confederate view that the states were sovereigns who entered a league and had the power to leave the league. That's all abrogated as a matter of law with this case.
Absolutely. So Hamilton's opinions about implied powers, which are not defined, are then read into our constitutional law by John Marshall.
And so in a way that I found much more persuasive, actually, than the way Hamilton argued it. Marshall sets up this very compelling distinction between what he calls substantial and independent powers, such as the power to make war, the power to conduct trade with other nations, and by contrasting them with what I guess you would call dependent powers, powers which are merely executive. They're instruments, not ends. And the incorporation of a corporation he places in the latter category.
Indeed. I've written down a couple of quotes here from Marshall's decision on those points. Marshall says, "This government is acknowledged by all to be one of enumerated powers, but there is no phrase in the instrument which, like the Articles of Confederation, excludes incidental or implied powers." So he says, well, in the first Constitution, it specifically said there are no implied powers. In the Philadelphia Constitution, it did not, which implies that there are implied powers. As they're not specifically forbidden in interpretation. That's a curious argument.
Yeah. It's the reverse of the argument of the canon of interpretation we discussed last week, or I guess 2 weeks ago, called the rule against surplusage, where if you read an ambiguous law in such a way as to render another part of the law mere surplusage, that must be the wrong reading. But here we're doing the opposite. We're reading the law, and because there's missing surplusage, then we've read the law correctly.
Indeed. Marshall goes on to say, in his opinion, although among the enumerated powers of government, we do not find the word bank or incorporation, we find the great powers to lay and collect taxes, to borrow money, to regulate commerce, to declare war. A government entrusted with such ample powers must also be entrusted with ample means for their execution. So he's asserting the supreme powers of the federal government should include these implied powers to set up a corporation.
It's a very practical argument he's making here, and he makes it very well, that if we're going to do all these weighty things, collecting taxes, moving monies from one place to another, then surely it's implied that we could set up an institution to do that.
Indeed, which was Hamilton's argument in his opinion on the bank. But we see here with Marshall's Supreme Court opinions that Marshall does far more for Hamilton's view, Hamilton's vision, than Hamilton himself was capable.
Yeah,
because Hamilton was a cabinet member. He was writing his interpretations, his opinions. Marshall is actually a supreme judicial officer. And so when he pronounces them, he makes them the law of the land.
Correct.
And that is by virtue of his previously asserted power, the judicial review, saying what the Constitution is. He's grabbed the authority to interpret it as the authoritative source, and now he has read Hamilton's opinions into the constitutional law. Now, in retrospect, we can look at these opinions and at the accomplishment of these cases and see in them the foundations of the current business climate in the United States. We can look at, in Marbury versus Madison, the routine of watching the Supreme Court cases come in every year and seeing which laws get struck down, which things get mandated by the in the federal government or on a state level. This is just the rule of the day, and it has been now for a long time. The Supreme Court did have a tradition of taking a more hands-off approach, most likely, well, I think entirely creditable to the more laissez-faire attitude of the Supreme Court justices themselves in previous days. There was nothing in the tradition of the Supreme Court or our political system that would have held them back from making the kinds of decisions that we see them making now, just on a routine basis. But they were not inclined to do so. They had more of a respect for the legislature and for the executive, and were self-restrained. In fact, it was really only self-restraint that held them back from the point where we see them acting just every day now. But the business cases, Dartmouth and McCulloch versus Maryland, this sets up a particular business environment, which was Hamilton's vision for the Union, that would be a nation of finance, a nation of manufacturing, a nation of employees. The Dartmouth College case gives us the foretaste of the modern corporate structure. States do not interfere. The federal government hasn't been talking about any interference in corporate affairs. Even antitrust legislation has largely disappeared from our political discussion.
No, it's been completely castrated.
It's an interesting thing. The antitrust initiative from the progressive era was really the last major attempt of the government to curtail the power of corporations that I mark anyway.
Yep.
There's the regulatory state, but the regulations have always favored large organizations and disadvantaged entrepreneurs, small businesses, and the like.
Yes, the regulatory state is not a curb upon the corporate state. It is a co-option.
Indeed. So we see with Marshall's opinions the foundations laid in law, in constitutional interpretation for the modern corporate business environment that we all live in and have inherited. That's not to say it couldn't be reformed in ways that are advantageous, but
as the progressive
this
example
all
shows us, at least for a short time.
indeed. We talked a bit before we went live about the future of the Union, and we both have a lot of respect for Hamilton in that we live in Hamilton's world. We don't have widely held private property. Americans are not economically independent as they were in previous ages. Hamilton certainly had a vision of national economic union and prosperity, of policies that would advantage the business owners and employees in America. And this was something exclusive in his mind to Americans, that we would have government law, special incentives made in law and in tax policy to advantage our own people. And I don't think that's a generous reading of Hamilton. I think that's what Hamilton really did intend and want.
Indeed, when you said a minute ago that we live in Hamilton's world, I would say we live in Hamilton's structure, but the inhabitants of that structure have been rather diluted with peoples for whom Hamilton's structure was not designed.
Yes. So though we live in Hamilton's structure, and that is a better way of describing it, we would do better with Hamilton's vision than we are doing now.
Well, I mean, for an example of this, I would point to Nelson Rockefeller. I would consider him the embodiment and apotheosis of Hamilton's vision for how the American people should live and how their society should be ordered. If you ever read Rockefeller's letters or his writings, he was very focused on the orderly conduct of business. He didn't create Standard Oil. He didn't create these massive trusts because he hated competition or he just wanted to be rich. He did it because he felt competition was disorderly, and that by bringing order to industry, everyone's lot would be improved.
I think that's a common position in the progressive era, not just of the statesmen who are talking about antitrust legislation. They're not trying to abolish corporations as such. They just want more of them. And that's also very interesting. There is also, as I mentioned before, the neo-agrarian viewpoint, which is not entirely gone. We have a number of writers in modern times that represent that, people like Wendell Berry, and the Southern agrarian writers, the authors of I'll Take My Stand and Who Owns America. They offer another vision that is decidedly more radical, certainly from our perspective, where we don't have a large interests of farmers anymore. They were certainly most interested in farming, but this also concerns small businesses, that we ought to have policies that distinctively favor small businesses, entrepreneurs, more widely dispersed private property, which I am certainly most sympathetic with. This also corresponds with Catholic social teaching, among other things.
Indeed, I eagerly await Dave the Distributist's explication of these very ideas.
Yes, I want to have conversations with him about that. It would be a lot of fun to go through Chesterton with him. Well, that is my syllabus on John Marshall's Supreme Court cases and his impact on this matter of the bank. And I've got more conversations sketched out for our series in the future, and I'm looking forward to them.
Spectacular, as am I. Let me just do a quick review here, and no, so strangely, our midnight stream has not garnered any super chats. I suppose the chat can be forgiven, all 10 of you. Well, Mr. Bagby, do you have anything to promote or announce or otherwise shill before we get out of here?
Yes, I've got several upcoming works that I've completed. I've submitted to the publisher a manuscript, a book called Washington and His Colleagues, which I've added a large appendix to, including Hamilton's opinion on the bank, Hamilton's report on the public credit, Jefferson's opinion on the bank, and other documents from Washington's administration. So it's got a big, hefty appendix on the back of it. I've also submitted to the publisher a biography of John Marshall, and I'm expecting these to be made available any day now. It's been a week since I've submitted them, and so I'll soon announce their availability. Watch my social media for that. You'll see them there before you see them on the website. So my handle on Twitter is @tallmenbooks. You can follow me there, and that is where you will see announcement of new titles such as these.
Frankly, Mr. Bagby, every time we speak, I cannot help but feel that I am losing ground, for my reading list expands beyond my ability to keep up every time we do one of these.
That's great. I'm happy to hear that.
All right. Well, thank you very much for your kind appearance and delightful erudition at this late hour. Chat, thank you for hanging in with us, and we will see you all next week at a